Thank you. Good morning, everyone. I wanted just to show my face so that I can close my video. Honorable members, let me take this opportunity to welcome members of the committee, the affected members,
Recording in progress,
the initiator and his team, and the legal team of the affected members. You are all warmly welcome into today's meeting. I don't know whether we do have apologies before us. I will be advised by you, Andile.
No apologies, Chairperson.
Thank you. If there are no apologies, we'll have to proceed. Honorable members who are today and the next 2 days holding a hearing on the SONA incidents of the 9th of February 2023, which the Speaker referred to this committee for investigation and report. I now declare the hearing open. I will ask the initiator to introduce himself and his team and to inform the committee of the purpose of the hearings. Over to you, initiator.
Thank you. Thank you, Chair. My name is Anton Katz. I'm a senior counsel and I'm the initiator, having been appointed as such by the State Attorney. I am assisted with the initiation and the evidence leading by Ms. Advocate Jade Aspling. She's immediately behind me on my right, and behind her is the State Attorney, Ms. Onel Marsh-Scott. Immediately next to me is the Parliamentary Legal Advisor, Mr. Andile Tetiana. The other members of the team who are assisting is Mr. Victor Ngaleka and Mr. Molisi Totti. They are sitting on my right, 2 seats away, and Mr. Totti is opposite me, who will be assisting with the protocols that are served today. We as the initiating team are ready to proceed. We're ready to put the charges to the 6 affected members. They received their notices of the hearing on Tuesday, the 7th of November, 2023. And perhaps before I take that step, perhaps I should just make 2 observations. The one is that 2 days ago, less than 36 hours ago, the legal team for the 6 affected members, who are all present in the chamber today, launched an application for a postponement of these proceedings. And before I ask them to introduce themselves and to motivate the postponement, if with the permission of the chair, perhaps I should just outline in 30 seconds what today's proceedings are about. The charges, as Chair, you have correctly pointed out, relate to the events that happened on the 9th of February 2023 during the State of the Nation address by the President of the Republic of South Africa. And perhaps in 10 seconds, I may put on the screen that which happened. Immediately thereafter, I will hand over to our learned colleagues to introduce themselves and to then indicate their stance. Chair, after the short video, I would propose that you make a ruling that the legal team for the affected members take 30 minutes to motivate why the matter should be postponed without interruption by the committee members. I would then have 30 minutes to rebut their application for a postponement, and they have 10 minutes in reply to deal with anything that I've raised in my rebuttal to their application for postponement. Thereafter, the committee members could address any questions or queries they may have to the respective legal teams. So may I ask that the short clip
On the
be
point of order,
played.
Point of order.
What is the point of order, Honorable Malema?
Chair, it is not the responsibility of the initiator to want to tell us how we're going to run the proceedings here. You can't tell us who's going to speak for how many minutes and who's not going to interrupt that person and who's going to respond for how many minutes. You can't tell us that. It's got no role to tell us that. It's your responsibility as a chair after the consultation with the team. You see, it's a problem, this thing that you hire minorities when you're charging Africans here. You did that with public protector. Now you brought a white man here who's coming to tell us what to do. We're not going to
Honorable
accept
Malema,
that.
can
It's
you
a
please
responsibility of a
can you
committee to tell us
please make
how
a
we're
point
going
of
to run
order so that I
proceedings.
can make a ruling?
Make a ruling. Make a ruling. But this thing
Then-
of bringing white people, when you are charging us, you bring white people to come and prosecute us. We're being prosecuted by a white man here, a white male.
Honorable Malema, can you stop there because you have made your point and I've heard you? I will make a ruling as the chairperson. Initiator, can you stop there? I will proceed with the chairing of the meeting, and I have acknowledged your point of order is sustained. I will make a ruling as the chairperson. Now I'm proceeding. I now ask the legal team because he has introduced himself and his team, I'm now asking the legal team of the affected members to introduce themselves, and after the introduction, and make their application. I will give them 30 minutes, of course, to motivate I'm allowing that. But before that, the legal team of affected members confirm with me the presence of all the affected members in the August House. Over to you, my legal team of affected members.
Thank you, Madam Chair. My name is Tembeka Ngugaitobi. I'm an advocate in Johannesburg. I am in this matter with Mr. Ramohale and Ms. Sekwe, S-O-E-K-O-E. We act on behalf of Mr. Malema, Mr. Shivambu, Mr. Ndlozi, Mr. Dlamini, Mr. Pambo, and Mr. Tambo. I presume that they are all present. Mr. Malema has already announced himself, and I've seen the name of Mr. Shivambu on the screen. And perhaps we should simply ask Mr. Ndlozi, Mr. Dlamini, Mr. Pambo, and Mr. Tambo to confirm their presence, because I've not personally seen them.
Can you do so, honorable members, as requested by Advocate Ngugaitobi?
Thank you very much,
Just
Chair.
to confirm.
Pambo. Thank you very much, Chairperson. Guyani Pambo here. I'm present.
Thank you.
Chair, I'm present, Marshal Dlamini.
Thank you, Dlamini.
That leaves Tambo and Mr. Ndlozi.
Thank you.
Chairperson, I'm here in Ndlozi.
Thank you, Dr.
Thank you. Thank you, Madam Chair. If I may then proceed, there are two applications that we've indicated we intend making. The first application is for the committee to appoint an independent chairperson who might either be a judge, a senior attorney, or a senior advocate to conduct the fact-finding inquiry, and the matter will then be remitted back to the committee for its final determination. That's the first application. The second application is for these proceedings to be postponed to either a date or dates in January or February. We will be indicating to our learned friends. the week in January or February that would be suitable. Let me start with the first application, which is the appointment of an independent chairperson to conduct the fact-finding inquiry. Firstly, the committee is bound by the common law rule against bias. Now, we don't accuse the committee of bias, but what we say is that the common law rule against bias means that you as the committee cannot be a judge in your own cause, and that it is important that there should be no perception, reasonable perception, that you are biased against the EFF. Secondly, you are bound by the provisions of Section 12 of the Powers and Privileges Act. Those provisions require you to ensure that the proceedings are reasonable and procedurally fair. We say that the only way to ensure that there is reasonableness and procedural fairness is that you should appoint an independent chairperson to conduct the fact-finding inquiry. And thirdly, you are bound by the Constitution, and I did not say that, it's obvious. But the requirements in Section 1C of the Constitution require you to ensure that you act rationally. And we say that the only way to act rationally in these instances is to appoint an independent fact finder. So let me start then with the first of those three propositions, the rule against bias. Now, the rule against bias is part and parcel of the common law rule of audi alteram partem, which is generally referred to as the natural justice. What it contains are two elements. The first element is that you should give a hearing to an affected party. Obviously, you are giving us a hearing. We are not objecting to that. But the second one is that the person who hears the matter should not be biased and should not be reasonably perceived to be biased. The problem that you have as this committee is that you are majority, according to the calculations of my learned colleague, you are 61% ANC members. You are sitting in judgment of your political opponents, the EFF. You therefore hold enormous power over your political opponents. And the issue at stake is a political issue. You have obviously framed it, or the prosecutor has framed it, as a breach of the rules. But what is clear is that on the 9th of February, 2023, there was a protest by the EFF against its political opponent, the President of the Republic of South Africa. Now, you may disagree with my framing of the issue, but that disagreement is of no moment, because what we argue is that the person who makes a judgment against the EFF must not only be independent, but must also be perceived to be independent. So we ask yourself, we ask you to ask yourself the question, whether any reasonable member of the South African public will perceive a hearing in which the ANC stands in judgment against the EFF as an independent hearing, particularly at the fact-finding stage. Now, this is not the same issue as presenting a bill for voting in Parliament, where majoritarianism applies. And this is not the same issue as deciding whether or not the public protector should be impeached, where again majoritarianism applies. This is an issue whether or not political opponents of the ANC in Parliament should be judged by the ANC. And it has severe consequences, not merely among the people that I represent, it has severe consequences among the voters. The effect of the matter is that some people in this country, more than 1 million of them, have chosen the EFF to represent them in Parliament. And although when the EFF is here, they are members of Parliament, the Constitution itself recognizes that they are opposition members of Parliament. That is why there is a rule in Parliament that there is a leader of the opposition. It is a recognition that they don't lose their political identity when they become members of Parliament. So we say that if you continue constituting the committee in the current fashion, you will fall foul of the common law rule against bias, and your proceedings will be unlawful and unconstitutional. So that is why we do not ask that the matter should not sit. We've never made that request. But what we do, we ask that the matter should sit before a neutral, independent chairperson to determine whether or not the political opponents of the ANC are guilty of misconduct. The other consequence of this is that if you look at the penalties that may be imposed in terms of the Act, the most drastic penalty is a suspension for a period of 30 days. Now, what that means is that the EFF, particularly its leadership, and I act here for the top leadership of the EFF, you can remove them from Parliament for a period of 30 days. And if you were to remove them in Parliament on political grounds, and not necessarily on misconduct, because we say that there will always be a stain that you are biased against the EFF because they are your political opponents. But if you remove them for a period of 30 days, what that means is that during that period, any deliberation, and it may even be a State of the Nation address next year in February, or it may be a deliberation on an important bill. But during that period, a significant part of Parliament that has been voted into by the public would not be able to participate, which means that this is not about Mr. Malema, but it is about the million or so people that have chosen the EFF to be their representative in Parliament. So, argument one, we say that you should remove the stain of perception of bias against yourselves as the members of the ANC. Now, that, of course, does not mean you individually are biased. What it means is that the law regards you on a just perception basis as reasonably biased against the EFF, merely on account of the fact that these are your political opponents. But even if you look at the nature of the charge, it simply strengthens the political bias. This is a charge ostensibly for threatening the president. But this is not just the president of the country, he is also the president of the ANC. You are also members of the ANC, and I accept that you are acting here as parliamentarians. But there is an uneasy feeling that you will protect your own president against the EFF. And that is why you have to remove that perception and appoint an independent person. That person may be a judge, they may be a senior counsel, they may be an attorney. But we cannot see the downside, we cannot see the harm. We cannot see anything that would be harmful to parliamentary autonomy and parliamentary rules if you were to appoint a judge to hear this matter. Section 12 of the Act does not prohibit you from doing so. It does not require you to sit as the disciplinary committee. It merely requires you to ensure that the proceedings are fair and the proceedings are reasonable and the proceedings are rational. And the way to achieve the object of the Act is to appoint a judge to conduct the fact-finding inquiry. So we say, as a matter of the common law, you are obliged to do so. And as a matter of the statute, there is nothing preventing you from appointing a judge to hear this disciplinary hearing. Secondly, are the provisions of the Act itself. I have already explained that those provisions of the Act requires you to ensure that the hearing is procedurally fair and the hearing is reasonable. It is unreasonable, it is procedurally unfair that you should subject the top leadership of the EFF to a disciplinary hearing that is presided over by its own enemy, political opponents. Particularly so because you, as members of parliament, are also witnesses to the incident. You are witnesses to the incident because this happened on the State of the Nation address. You've also made a decision to institute the charges. These charges were not independently instituted, they were instituted by yourselves. You've also made a decision to choose the initiator, And obviously, you've tried to choose the initiator on the grounds that he is independent, which we appreciate. Mr. Katz is an independent man and is a colleague at the bar, and we have a lot of respect for him. That is fine. But what we ask for is that in the same way as you have appointed an independent prosecutor who is truly independent and who is not political, you should also find it in yourselves to appoint an independent judge so that we can debate whether the EFF is guilty or not. There is no benefit to Mr. Katz to sit here and prove a case in front of the same people that are witnesses, same people that have decided to charge the EFF, and same people that will be making the deliberations. So in sum, on this point, you are the judge, prosecutor, and sheriff in one. That is just wrong at so many levels. It's wrong as a matter of constitutional law, it's wrong as a matter of the common law, and it's wrong as a matter of the statute. We have seen the rules that Mr. Katz is permitted to be appointed as a prosecutor, but we say that there is a reason you chose him. You chose him because of his unique characteristic as an independent man, and may I add, also an honorable man. We say you should do the same thing for the appointment of the chairperson. And there is then the third requirement, which is you are bound by Section 1C of the Constitution, and that section requires you to act rationally, and it requires you to act within the scope of your powers. We say the request we've made is within the scope of your powers, but it would also be consistent with the principle of rationality. And if you did not do so, you would be acting irrationally. And it does not mean that you will necessarily find the EFF guilty. You may well find them not guilty. But what you will never remove is the stain that political opponents of the ANC, if they don't please the ANC in parliament, will be subjected to a disciplinary hearing, which ultimately is deleterious to our constitutional order and limits the ability of MPs to be robust when they are inside the precincts of parliament. If the EFF is guilty, as seems to be the view, if Mr. Malema is guilty, let a judge tell him that he is guilty. He will accept that. What is unacceptable is that he should be told by his political opponents who decided that he is guilty, who witnessed that he is guilty, who chose to charge him, and who have a political incentive behind his conviction and the imposition of a penalty against him. So let a judge, let a neutral person, let an advocate, let an attorney make this determination. It is a grave determination, and it should be made independently of yourselves. Now, that, of course, is not to cast an aspersion on you as members of parliament, but it is to state the reality that he cannot expect to have a fair hearing when he is subjected to punishment by his political opponents. So that's the first request. We ask you that you should appoint an independent person, and that person, we say, can be a judge or can be a senior counsel and can be an advocate, an attorney. If you did that, we will be back here in January or February. We will take 3 days or a week. We will finalize this matter, and you will hear no objections from us, at least on the process. And you will get the evidence you want to hear. And if you are confident of your case, you should not fear the subjection of this case before a judge. It is only when you are not confident of the case that you actually want to preserve it for determination by yourselves as politicians. The second application we want to make is a practical matter. This charge sheet was delivered on the 7th of November, and it schedules the matter for the 20th, 21st, and 22nd of November. The charge itself emanated from an incident on the 9th of February, 2023. So which means that for some reason, Parliament has delayed by 10 months. We have not been given any explanation why you have delayed for 10 months. If you thought this matter deserved to be dealt with speedily, expeditiously, and someone says even importantly, we have not been told why you have delayed for 10 months. So you've taken 10 months to constitute a charge on a single incident, one incident. So given that Parliament cannot explain why it has taken them 10 months to prosecute, there can be no urgency in having this application or this disciplinary hearing dealt with today or tomorrow. This is an application that can be dealt with in January or February. There's no reason why it should be dealt with this week. It can be dealt with in January or February. That's number one, is there has been an undue delay by Parliament in instituting these proceedings. And given the undue delay that has not been explained by Parliament, it is grossly unfair and unreasonable that we should now be railroaded, that the matter should be dealt with on such expeditious and speedy grounds. Now, I discussed this with Mr. Katz on Sunday. And then one of the points he made to me was that the rules say you are only entitled to 5 days. Now, that is true. But you must also, as Parliament, act expeditiously if you take these charges seriously. You can't wait for 10 months and then after 10 months, give us 5 days notice. That is just grossly unfair. You should give us enough time to consult, to study the video, to prepare, to raise any points we want to raise, to issue subpoenas, all of those procedural requirements. This is not a Stalingrad application. This is a sensible application to have this application dealt with properly in January or February. If you force us to carry on with a matter that we are not prepared, we are just going to sit here, listen to your evidence, and then thereafter ask for a postponement, because there is no way that we can run this case reasonably within such a short period of time. The second reason is that there is an application against Parliament that is in the High Court on the 4th of December. It has not been brought by this group of EFF MPs. It has been brought by a different group of EFF MPs. But it challenges the validity of the disciplinary proceedings against the EFF arising from a July 2022 incident. But these incidents are related because there is a commonality, which is the persistent view that has been taken by the majority party to prosecute the EFF for what it perceives to be infringements taking place inside Parliament. If that application is decided in favor of the EFF, then your committee will not be able to sit in any event. The current accused, let me say, charged or implicated members, Mr. Malema, Mr. Shivambu, Mr. Ndlozi, Mr. Dlamini, Mr. Pambo, and Mr. Tambo have applied to join that application. And it will be heard on the 4th of December. So it's imminent. It is not as if it will take a long period of time. And one of the points that will be argued before the High Court is precisely this point of the incorrect composition of the committee. Now, the point may or may not be good, but it is irrelevant because the judge is going to make a determination on the 4th of December as to whether or not the committee currently as it sits is properly composed. So we ask you to remove the problem by appointing an independent person. But in any event, the matter is going to be decided by the judge on the 4th of December through interdict proceedings. And then the third point is that there has simply been insufficient time to prepare, and I've already made this point. Once you've taken 10 months to prosecute a case which you claim is a simple case, you cannot say to the accused, you only have a week to prepare. You have to take into account that you've given yourselves 10 months to prepare. Right? Parliament took 10 months to prepare this case. It cannot give the EFF 10 days to prepare. If the Parliament believes that 10 months is reasonable for it to prepare its case, it follows as a matter of logic that it must also give the EFF not 10 months. We ask only for 1 month. We will be back in January. We will be back in February. We can fix a date, fix a time. We're going to run the case. But the truth is that there has been insufficient time to prepare. And the sufficiency of the time can be judged by the fact that you yourselves took 10 months to prepare this case. There is a problem again about the discovery of evidence. That's number 4. One of the charges you make is this idea that there was a threat or intimidation of the president by the EFF. We're going to deal with this in evidence. But we've asked for a subpoena to be issued against the speaker. We will also ask for a subpoena to ask the president whether or not he was threatened, because an allegation of threatening a person is a subjective allegation. It is similar to the provisions of the Intimidation Act of 1982, which has Section 2 of which has recently been declared unconstitutional. But it is a subjective charge. In other words, I cannot say that X has been intimidated or threatened if X says I was never threatened. We know that you don't intend to call the president and you don't intend to call the speaker. But we want to issue the subpoena against the speaker or the president so that they can explain how they have construed the rules, and the president can explain whether or not he was threatened, because you've elected to charge us for threatening the president or storming the stage in a threatening manner. But the stain of the threat is to be felt primarily by the person who is alleged to have been threatened. It is a subjective charge. So whether or not the initiators will be calling the speaker or the president, we will be asking the committee to issue a subpoena against the president, or asking the speaker to issue the subpoena. Now, this is one of the reasons why this must be dealt with independently, because we don't want to place the committee in a position where it must make radical decisions about subpoenaing its own political leaders to appear in a disciplinary hearing. Whereas if this was an independent judge, it would be easy for an independent judge to say, I think witness X is irrelevant. I think witness Y is relevant, and therefore I'm declining your subpoena or I'm granting your subpoena. The problem here is that you have constituted yourselves as a political machine, and that we say is wrong when you are running a disciplinary hearing. So, but we say there is evidence we want to be discovered, including subpoena. But we also want the entire video. The video that we have been shown is very skewed. It shows a portion of the stage, and it is in circumstances where we have to interpret what were the EFF members that went to the stage trying to do. Were they trying to threaten the president, or did they have a different object? Could the president reasonably, on what can be perceived, be threatened? Or is the allegation of threat of the president simply made up in order to bolster an otherwise non-existent case? But those are matters that will be dealt with in due course. For now, what we say is we want a postponement so that we can finalize the question of discovery, so that we can finalize the question of who must be subpoenaed and who must not be subpoenaed. So we say that in those circumstances, it is just impossible. I mean, obviously, you can take the political decision to force the hearing. You've got the majority. There's nothing stopping you from doing that. But we say that if you took that view, it would be susceptible to judicial review. The most pragmatic thing is to postpone the hearing for a month, give us until January, or give us until February, and give us a week in January, give us a week in February. We reconvene, we call the witnesses. But in the meantime, it also gives you a chance to deliberate on this idea that we have proposed, that you are in fact under an obligation to ensure that there is independence and a perception of independence. My colleague, Mr. Ramokhale, has prepared written argument on the point I've made about the appointment of an independent panel. We will be submitting those shortly for the consideration by the committee. Thank you. I think I've probably not exceeded my time. I don't know, but thank you, Madam Chair.